very much. Good morning. Can everyone hear me? Yes, I think I've come up there. I'm delighted to welcome you to this discussion on European class actions this morning. For the next 45 minutes or so, we're going to consider how collective proceedings have evolved throughout Europe in recent years. And we're going to look at the impact of the availability of litigation funding for such claims. We're going to look at four broad topics in this discussion. Firstly, we're going to look at the existing mechanisms for class actions in our speakers' jurisdictions. Then we're going to consider the issue of costs and litigation funding before turning briefly to some issues on quantum in our speakers' different jurisdictions. And then we're going to conclude by looking at the likely developments to come in this area. In doing so, we expect there will be some interesting points of divergence, perhaps in terms of the payment of damages by cheque, and some points of comparison with the fascinating insight we've just been given by Tim, Craig, David and Michael in respect of the US market in this area. So firstly, I'd just like to introduce our speakers this morning. As you can see online, we have Dave Coleman, who hopefully can hear us and see us.
Yes.
Excellent. Dave is a managing partner at Coleman Legal, based in Dublin. He has over 30 years' experience of group litigation, covering a broad span of issues, including historic sex abuse cases, product liability claims, and property damage claims. Some of Dave's most high-profile cases include the well-known metal-on-metal hips claims against Depuis, a group of claims against ACC Bank by bondholders, and a group of claims against Meta by content moderators. Turning now to Cristian Gual. Cristian is a partner at Uría Menendez, based in Barcelona, and leads both the international arbitration and litigation team for the firm, and also the dispute resolution team in Barcelona. Cristian has a wide range of experience in dealing with collective proceedings in Spain and of international claims involving complex civil and commercial disputes with a focus on competition and corporate disputes. Finally, Dimitri Lecat. Dimitri is a partner at the Freshfields Paris office. In addition to his regulatory and enforcement background in the commercial, banking and finance sectors, Dimitri has extensive experience of class actions, in particular those arising out of product liability claims. He has advised on the full spectrum of proceedings in relation to emissions claims against VW in France, which I know lots of delegates will have experience of too. He's also advised the manufacturer Smith & Nephew in respect of the metal-on-metal hips claims in France, and he has also led the Volvo Trucks defence on cartel follow-on litigation, again in France. So whilst as we've heard from Tim and the rest of the panel that collective redress in the US is a huge market, and Europe perhaps is not quite comparable in terms of scale, it is a rapidly growing market, as we've heard from several speakers over the last day and a bit. And going back to the report that Chris mentioned this morning from CMS, another statistic that I'd just like to highlight before we get on to the detail of our discussion is that in addition to the huge market share that the UK has, 78% of all class actions in Europe come from the UK, the Netherlands, Germany and Portugal. And as we all heard in the very interesting discussion that we started this conference with yesterday in terms of the Portuguese market, there has been a huge explosion of those claims here over the last 4 years. A particularly striking statistic, following on from Andrew's very interesting keynote speech this morning in terms of CAT claims, is that there are 500 million class members in claims in the CAT in the UK at the moment. There was also news over the weekend that many of you will have seen that the organisation Client Earth and several national NGOs have made formal complaints to 3 governments, including the UK, France and Germany, in respect of the diesel emissions scandal. Now, whilst many of those claims have already been issued and are underway in several jurisdictions, it may be that this recent complaint sparks further litigation in this already very significant piece of litigation. The report that Chris mentioned this morning from CMS also made a very interesting discovery which is that for the very first time across Europe, the number of opt-out claims has exceeded the number of opt-in claims. So we're really at a very significant turning point in terms of the European market. Now, turning to our first topic, the procedural mechanics for collective redress in our different jurisdictions. Despite the Representative Actions Directive requiring that all member states have at least one collective redress mechanism in place from June 2023, this date has been and gone without comprehensive implementation of the directive across the EU. As Maria Jose set out in her keynote speech yesterday, even for those member states which have transposed the directive, there is significant room for manoeuvre for member states to implement the directive in the way they see fit. And a key differential between member states is whether they select opt-in or opt-out proceedings. So as a result, we're left without a coherent approach to collective redress within the European Union, and we're left with something of a patchwork quilt of systems across the continent for all forms of group litigation. Now, France is, if I can say it in the run-up to Christmas, on the naughty list as not having transposed the Representative Actions Directive as yet. And I'd like firstly to begin with you, Dimitri, and ask you to really help us understand what the existing framework is for collective redress in France and how that might change.
Sure. Thank you very much, Meghann. I won't deny that France is in the naughty candidate side. And just as a preliminary remark, there is potentially an explanation to that, which is partly legal, partly cultural. There has been long, and still probably be, a certain hostility towards class action in France, where the US-style class action model has really been seen as a thing not to do, and this is no offense to our fellow participants to our previous panel, but this is really something which has driven parliamentary discussion in relation to introducing class action in France for the last decade. So it took a decade to introduce a class action system in France. This has started with consumer claims in 2014, and then has been extended to health, discrimination, environment, and in 2016, and personal data in 2018. 10 years after, it's fair to say that the introduction of the class action in France is a partial failure, particularly in view of the relatively small number of claims and proceedings brought before courts on the basis of this regime, only 37 claims for the last 10 years. And the fact that none of those claims have led to a final judgment adjudicating liability to date. And it is interesting to see that the ongoing debates surrounding the implementation of the directive, which is still not implemented in France, so another bad reason for being talking about France today, show that there is no clear consensus about the one who supports the status quo and the one who would like to take this opportunity as a way to try to revolutionize the French system. We are seeing emergence of very different draft bills going opposite directions on the back of political instability in France. So it is very difficult to tell you today what is going to emerge, probably next year, when the directive is set to be implemented. Having said those preliminary remarks, there is 3 points I wanted to focus a bit on, which are main features of the French system and which may give you an explanation why the results in relation to the French class action system is a bit disappointing, at least as perceived by on the claimant side. The first one is the fact that France has entrusted a monopoly for class action to a limited number of registered, qualified entities. Just to give you an example, only 15 consumer associations are entitled to bring a class action in France under the French class action regime. And there is, of course, a debate in the course of the implementation of the directive whether or not France is going to extend this to other associations, in particular to ad hoc associations. And we are back in the opposition between the statu quo and the potential revolution that I was mentioning. You see pros and cons on both fronts, and so it's quite difficult to see where we are going to land on this one. Second, France has decided to adopt 5 separate regimes which work in silos. And so it creates lots of difficulties when you have crossover situation, because you are litigating simply to know whether you are going to apply the consumer class action regime or whether you are going to apply the environmental class action regime, which is probably a dispensable source of litigation, and that's a personal view. But once again, in the course of the discussion toward the implementation of the directive, we will see whether whether France is going to extend the scope of class action regime to areas where it still is not existent. And I'm just give you 2 examples. There is no possibility to bring securities class action in France today. And so we will see whether the directive is going to change that. And there is another point which is a bit controversial, which is B2B class action, i.e. the French system is a C2B class action, consumer against business class action regime, whereas there are proposals to change this and to open the system to a B2B, business to business class action regime. And the last point is in relation to opt-in. France has adopted an opt-in mechanism, but which is a very, very specific one, because the class is decided on the class is decided on the basis of a very small number of participants. So it can be 2, actually, 2 or more, without any early process of certification. And the class is constituted only when the liability has been finally decided. So it can take ages before you know what is going to be the shape of the class. And of course, this raises at least one problematic issue, which is settlement, because it's very difficult to settle when you do not know who you are going to settle with. And you are not going to know that for years in the French system. And so there is some frustration, not only on the claimant side, but also on the defendant side, because a number of targeted defendants would be ready to consider early settlements in the course of the French system. And they cannot do that realistically for the reason I just explained. So maybe the question for me would be whether opt-out is going to be implemented in France on the back of what I just said about some sort of limitation about the opt-in mechanism in France. Of course, educated guess, but there are a number of legal limitations which have always been taken into consideration by the French Parliament to rule out the possibility for an opt-out class action in France. So remains to be seen when the directive is going to be implemented, but best guess, at least by me, will be that we will probably reform the opt-in. We will probably not go to opt-out.
Thank you very much, Dimitri. Cristian, could I bring you in at this point? Maria Jose told us in the keynote speech yesterday that we're awaiting some exciting developments in Spain. Yeah. So could you enlighten us about what's to come and perhaps compare it to what you have now?
Absolutely, a pleasure, and thanks everyone for being here and your interest, and of course for the organization for giving me the voice, which might be a little risky, right? One thing I'd like to say at the outset is that those exciting news from Spain that Maria Jose was very pertinently referring to may have been derailed, perhaps dramatically, hours from now, the week before, just because the whole project that was aimed at implementing the Representative Actions Directive, which is one of, I think, the main driver of Maria Jose's statement, has gone back to square one due to some political discussions and evolutions in the parliament. I can dwell into that a little bit more later on. That brings me to the point which I wanted to make, and based on some of the discussions and questions and statements that I kept on hearing these days. Right? Yesterday we heard, well, in Europe we're getting the sense of we want to get something of that. We want to get some of the class action, US class action style litigation. Well, I think it is fair to say that that is true to a large extent for a part of the section and a part of the population, but it is truer, I tend to think, that we want to have something like that, but European style. Right? There are a lot of assertions that are, and assumptions that I believe are being made, that from what we keep on hearing and as we keep on the conversation with our US colleagues, appear to be nothing more than that, perhaps too radical and too simplistic assertions. One of them, in my opinion, may be the equation between collective redress generally and opt-out and some other mechanisms. The reason I say that is that opt-out, pure opt-out, may not be, or pure class actions, may not be the only way to bring in interests or litigation that go beyond the individual interest of a particular citizen or business or whatever, and that does increase exponentially the risk and the exposure of the company that's being sued. That may certainly not be the only way, and certainly it's not been the case in Spain, and that's where I want to go directly to your question right now. What's exciting about Spain is that Spain is regarded as a very active market. You can tell that, and Dimitri, you may know that very well also. I'm also, full disclosure, working on the defense in the drugs cartel cases in Spain, right? So, and that is a perfect example of what's the problem that you face when you do not have the procedural tools that adapt to the type of discussion or interest you're dealing with. Let me put it that way. We may end up having the best drivers in the world, in the jurisdiction. We may end up having the best cars, for the race, but if the road is bumpy, that's completely useless. And to me, how bumpy is the road has to do with how is the procedure designed at each and every jurisdiction. One point that was also made by Maria Jose was this, again, possibly too simplistic contrast between common law jurisdiction and civil law jurisdictions when it comes to the procedural underlying aspects. One main thing there is how rigid is the system, how flexible is the system, and to what extent does the procedural system or rules allow for a proper discussion. Now that extends to basically everything, but crucially to the economic discussion, underlying discussions that were referred to yesterday. And that's absolutely crucial when it comes to the foreseeability and the measurement of the risk of what you want to do. But it also has to do with the depth of the discussion that you may have to face at the certification phase, for instance, if you have one, right? We were going to have one in the projected implementation of the RAD. Now we don't know what's going to happen. I can, of course, Meghann expand on that, and Meghann and everyone expand on the details of the Spanish implementation later on if you want. But that was aimed precisely at tackling one of the problems in Spain, which is the underlying procedural rules, right, that are making it perhaps too difficult, both for the claimants on some aspects and for the defense on some other aspects, to actually deal with this sort of more complex, more general collective litigation, right? So that's the main point I want to call the attention on by now, which is the crucial importance of the cultural approach, if you will, but basically so the procedural underlying rules, and how does that limit what you can or cannot do then with the tackling of these matters.
Thank you, Cristian. Can I check if, assuming, and it does sound like a very exciting time, and lots can happen, it seems, in the near future. If the political differences are settled and the draft of the implemented directive goes forward, can I assume that that would be an opt-out process, unlike in France, so that there is a willingness to have that system in Spain?
I mean, the system the discussion in Spain, it's already 2 years long.
Right.
It was, and it's very focused and ambitious in the sense that the promoters of the draft implementation were clearly and explicitly advocating for the implementation of a fully opt-out regime, a default opt-out regime. That doesn't mean that there were options, and the legislation was already contemplating a sort of a mixed option under some amount thresholds. You could, and eventually with the last reforms that were attempting to be introduced or attemptedly introduced by the socialist government, right, in the parliamentary stage, they were almost, in some cases, opt-in would become mandatory. Mm-hmm. But it is certainly true that the design of the whole project was certainly, let's go full throttle, right? Let's bring in an opt-out regime in Spain and see what happens. This is also, by the way, possibly the very reason why, at that stage, everything has been halted.
Yes.
Because that prompted a lot of
anxiety,
so to say.
Yeah.
Right.
Can I, in fact, turn on to our second topic now, and that's the hot topic of costs and litigation funding in the European market. The availability and regulation of litigation funding obviously varies enormously from country to country, and it has a huge impact, as Maria Jose said yesterday, in terms of forum shopping as to which jurisdictions are considered attractive or even viable venues for collective redress. So actually I'm going to stick with Spain for the moment and bring you in, Cristian, on this topic, if I may. Where are we in terms of availability of litigation funding in Spain at the moment? I appreciate things are in a state of flux for the future, but what is the market like in Spain at the moment?
The thing basically in Spain is that we are where we want to be, to put it very bluntly, and that means that they're completely unregulated, right? So there are no rules that actually would prevent or limit or allow for an orderly discussion as to the sort of model underlying the way you build up these cases. You build in these cases, right? Assignment of claims, this sort of thing. So it's pretty flexible from that perspective. It is relatively easy to put claims together, right? Irrespective of whether or not we have a class regime, but that's technically possible from a purely procedural perspective, and very hard for the defense, I have to say, right?
Yeah.
To fight on that. But at the same time, the real, I would say, the thing that people need to bear in mind when it comes to Spanish litigation is that it isn't extremely costly, right? So far, the problem of collective redress, it's way more addressed in terms of what's the exposure that that's going to bring with the companies in terms of how easy is it going to be to bring in cases all together in one single stage or set of proceedings, than is it really possible to launch a massive set of claims or one single massive claim, right, against one company or set of companies. And when you take that, Spain, it's not an expensive country, right? It's the exact opposite in terms of archetype as you would assume from the UK, right? And that explains a lot of things. That explains then why funding may not have been necessarily regarded as something extremely needed or necessary to bring in those cases. Plus, but that's a point that comes in from the debate that was prompted from the attempted implementation of the representative action directive, the position of the consumer associations to that respect has very clearly been one, I would even dare say, somewhat aggressive against the funders, in the sense that, and defensive, if you want, both aggressive and defensive. Having said that, are there any rules or is there anything out there that would prevent funding from existing? Or certainly not. Funding exists. There are projects. They are quite obviously so at the gates, right? And waiting for things to clarify a little bit. That is, I would dare say, fairly obvious, right? And then everything remains to be seen. The attempted implementation, again, I keep referring to that because I believe that sooner or later that is going to be somehow put back into the debate, right? But it didn't regulate funding, but it did regulate some aspects that ancillary touched on funding, such as disclosure at the certification phase of the funding agreement, right? In a quite flexible way. Court control or supervision of the funding clauses or arrangements at the certification phase and potentially at the settlement stage, right? Which was being regarded, I would say fairly so, as something that was clearly disincentivating the way, whether or not funders would be interested in the class action regime. And some interesting considerations when it comes to the giving the undistributed funds back to the defendant, which was very daring, I might say, also from the perspective of the Spanish attempted regulation. I think that covers it.
That's very helpful.
Right.
Yes, to understand. And I think by way of contrast, I'm going to ask Dave if he can participate at this point in relation to the position in Ireland in respect of litigation funding, and what I understand was a potential development from the Law Reform Commission of Ireland's report last year. But could you bring us up to speed, Dave, on what the position is at the moment for funders?
Oh, I can, yeah. If you have Dimitri there on the naughty list, I think Ireland is on the very, very naughty list. In truth, we have no class action structures in place at all. But that's not to say we don't have collective redress structures, which are in effect homemade. There's no statutory guidance, very little judicial guidance, and it is left really to the plaintiff and the defendant in a mass tort to work out how best to proceed. Quite clearly, there is in existence an act from 1634 when the British ruled called the Maintenance and Embracery Act, which makes it illegal, although not a criminal offence anymore, to engage in either maintenance or champerty of claims. Maintenance is where the funder has an interest, and has no interest, and champerty is where they have an interest. So the only recent judicial acknowledgement of the 20th or 21st century is a case called the Green Clean Act, which was a waste company, but it allowed for an element of after the event insurance, which I suppose is a little bit of progress. But the reality that faces plaintiffs in mass tort is, of course, that they're relying on their lawyer to fund the outlays, run it, win it, and not charge them too much. So the onus very much is on the lawyer, on the plaintiff lawyer in Ireland. And I'll give you an example of that being the Meta case. We act for many moderators throughout Europe who have never been to Ireland. They only are litigating in Ireland because Meta's head office is in Dublin. And these moderators are claiming damage as a result of what they have seen, etc. We have been challenged left, right and centre, of course, by Meta, who are providing enough resources, they think, to actually see us off. In fact, we've quite successfully survived German litigation and are now looking to have a seminal case heard in Ireland whereby any European moderator can sue at the head office jurisdiction. So it really is, I suppose, you make it up as you go along. If I could give you another example, just briefly, or two examples. One is that we're acting for many young people in Malawi who were abused by an Irish religious person, and we were successfully able to claim jurisdiction in Ireland and have it set there, but we negotiated what we called mid-Atlantic damages, which were I suppose a halfway point between the very generous damages given in Ireland and the not so generous damages that would be available in Malawi. And an example of how much the plaintiff lawyer is on his own is we have a case with 2,600 plaintiffs in it, based in the northwest of our country, where the blocks that built their houses are defective. And in each case, we've had to issue a separate writ, because there is no such thing as collective redress. But learning from the French, because we have an involvement in the PIP claim in Paris, the breast implants, we were able to encourage the Irish courts to accept a Dropbox system whereby the claims were dropped into the box and the defendants dropped in the appearances, thus stopping the statute against our client and preventing us from taking advantage of driving too many cases through the courts. So we are making it up as we go along, and I don't think it's very satisfactory at all that we do so. And I do think that the Representative Actions Directive was deliberately, I suppose, shackled by the government because they make no allowance whatsoever for legal fees. So only one body, consumer body, has signed up to the transposed directive, and there's no interest in it whatsoever because everybody is left to their own devices. So it's quite clear what the politicians think of collective redress and class actions, and it is up to firms like ourselves to fund these cases and drive them forward through the courts. So it is a bit of bare knuckle fighting, to be honest, and it's not acceptable in my view. But there is no appetite, given the dependence of Ireland on overseas investment, for that system to change anytime soon. So I suppose that, in a nutshell, that's where we are with this. We have been forced to look at EU law, to look at Frankovich-type damages for failure to transpose and implement these laws. And that case I referred to in Donegal will likely end up in Europe, and we will likely be seeking Frankovich-style damages for these people, which, once again, to wash our own linen in Europe, to my mind, is a failure not only of the judiciary but also of the executive in their direction of how group litigation should be handled in our country.
Thank you very much, Dave. It's really interesting to hear that perspective. I think you've already given your prediction for the future there in terms of the availability of litigation funding, but I'm intrigued as to whether you think there is any impact really from the Law Reform Commission's report, and whether that will perhaps start to pave the way for future changes.
Well, you can go back to 2007 when the current Chief Justice, he authored a report on collective redress, which of course was not implemented, and we see absolutely no reason why any report coming out now will only lead to plus ça change tout la même. There's no doubt about that. There is no spirit, there's no willingness to change at all, and it is politically driven. So it is up to people like us who are out there, in effect, in the courts, advocating for mass tort, to actually build up our own precedents and hopefully to build a system that is somehow exclusively opt-in, obviously, because there is no opt-out mechanism, because there's no mechanism. And it's up to us to put the infrastructure privately in place to do so.
Thank you, Dave. I think, if possible, I'd like to stay with you for our last topics in terms of quantum and then future predictions. And we've looked at some of the future predictions as we've looked at the other areas. Dave, I think you mentioned in the context of your work on the Malawi case, in that group litigation, that there was a particular incentive because of the high level of damages awarded in the Irish High Court. Could you just explain to us what the position is in terms of remedies and damages trends generally for collective actions, or rather group litigation in Ireland?
Yeah, I think, yes, I can address that point. There has been a government-driven, I suppose, bind on the allocation of damages by the courts, in that they have driven down access to, say, damages for personal injuries, etc. And to my mind, that's to be welcomed in some ways, because, you know, we live in a very competitive world, and we were a bit of an outlier in relation to the quantum available. However, the quantum available still dwarfs what would be available in Germany or France for similar type of, in effect, a tort of injury. We have a common law jurisdiction, so the British and our system are very, very similar. So all of the heads of damages that would be recoverable in a mass tort in England are available to us in Ireland. So we have adopted in full the common law system.
Can I ask, Dave, what's the position in terms of punitive damages in the Irish jurisdiction?
There are two types. There's punitive and aggravated damages, and they are, I think, quite loath to give them, although I'm looking for one in my case at the moment, so that's why I'm not with you. And apologies for not being there. I think it's a brilliant event. The courts are loath to give it, and they are not going to front load damages by a multiple of the general damages. The general rule of thumb would be you may see 20 to 25% unless there is a fraud on the court. If there's a fraud on the court, then you will see a completely different regime fall into place because the judiciary will protect itself.
Thank you, Dave. I'd like perhaps to come back to you, Dimitri, and take your perspective on damages in France, in particular this issue about punitive damages. What's the position there?
Position is very clear. As a pure civil law country, damages are intended to compensate a loss, not to punish. So there is no punitive damages at all under French law. We can see in certain circumstances assessment of a compensable damage, which is a punitive one, de facto, given the fact this is done. But as a matter of law, anything which is going to be close to a punitive damage is going to be quashed by the French Supreme Court on the basis that this is not what a damage is supposed to be. What is also interesting to note in the French class action regime is the fact that, for the same reason I explained at the very beginning of our panel session, France has tried to limit remedies more generally available to claimants, and so you can get damages in the course of a genuine French class action, but you cannot obtain the annulment or the resolution of a contract if this is the proper remedy to be obtained. At the same time, certain type of damages are available to a claimant, but others are not. Just to give you an example, in the consumer class action regime, physical damage are not compensable, environmental damage are not compensable. And so you can see the limitation of the regime, and there is a clear trend in the discussion about the directive to open the gate and to make sure that the available remedies will be much broader than what is currently the state of play. And just to finish on the last note, and probably a sort of French touch, if I may say so, there are very controversial discussions in France about the implementation or the introduction of a civil fine, which is so French, backed on the civil indemnification proceedings, which would be paid to the state and which could go up to 3% of the relevant company turnover. And this could be worldwide, so it could be massive. For the time being, we believe that this civil fine is probably not going to stay in the current discussion, but you can see the confusion of philosophy between what is supposed to be a mean to get access to justice to a number of people and a regime which would also be aimed at punishing a conduct which is already available at numerous occasions in the French system. So, personal view, probably not something we should do.
Thank you. And I think we can, as I say, we've commented along the way on what we see are the future trends and predictions. But just if I could just direct that question at you, Dimitri, before I come to Cristian. Any further observations about what's to come in France in terms of collective redress?
With great pleasure. So, as you can see, the genuine class action regime produces consequences which are not ideal to develop not a class action business, but at least a class action activity in France. And one of the key markers of that is the fact that, to the best of my knowledge, there has been no genuine class action proceedings initiated for the last 2 years, which is testament of what I just said. Does it mean that there is no mass claims in France? The answer is clearly no. Because claimants have been very creative. They have used different means for the same purpose. They have circumvented the class action regime and used other mechanisms in order to bring mass claims before French courts. They did so on the civil side, either on the basis of sui generis association being empowered by hundreds or thousands of claimants in order to conduct proceedings in France, or even with SPVs, which have acquired portfolio of claims and have decided to bring claims before French courts. Claimants have also done that on the criminal side, which is probably another specificity of the French system, because civil parties, so victims, injured parties, have the ability to join criminal proceedings and a criminal trial and to obtain compensation of damage before a criminal court. And this is very attractive to claimants, actually, because the public prosecutor is going to do the job. This is open to individuals, but also to companies. This is quasi-free justice. And there is no limitation about the kind of damage that you can get from a criminal court versus what I said about the class action regime. So the criminal route is still very commonly used by a number of claimants. And there have been very recent examples of that in the product liability sphere as well.
Thank you, Dimitri. Cristian, you've heard from Dave and Dimitri about how creative claimant firms and parties have to be in those jurisdictions. And in terms of Spain, what is the landscape like for the future, do you think? Does there need to be that same creativity?
It's going to be one of exponential creativity. Yeah, it very much so. Let me quickly touch on one of the things that you mentioned before. It is that tension between purely compensatory approach to damages and punitive or the like punitive-ish damages, right? Because while on the one hand it is perfectly clear that in purely conceptual terms, in theory, in Spain, it is obviously clear, right? The technical answer is that there's no room for punitive damages or nothing that goes beyond the purely compensatory approach to monetary claims, right? The truth is somewhat different, I would say. And it is a function of the way and the laxitude with which the approach to quantum is being conducted at the end of the day in each and every proceeding. So let me put it that way. The phenomenology, right, just très français, phenomenology of how these discussions are handled and how are they eventually resolved with a somewhat surprising an easy resort to estimation of damages ends up bringing in, perhaps unintendedly, but there are voices very explicitly and willingly and with full intention advocating for that. It's bringing in, I said, some sort of more deterrent punitive approach from the perspective of the compensation you're aiming at. And from that perspective, I believe that Spain, with all the problems, still remains or is going to become an attractive jurisdiction, which is at the same time promising for one side of the players and concerning for the other side of the players, one might say. So that's one of the things. And then the second thing I would tend to say in terms of, I mean, I don't want to be too oracular here, but all these years of discussions about how problematic it has been in Spain to tackle the shape of the litigation, the massive litigation that we have to handle, first with the financial consumer litigation in the post-crisis years, afterwards with the explosion of the cartel damages claims, and trucks being one salient example, right? But not the only one, is that it has brought in a lot of discussion, a lot of willingness, and a lot of players, I would say, which is all of which brings me to say that what I said at the outset, that we're going to see a lot of creativity, even if I think so, even if the project is as of now derailed, I don't think that is going to mean we come to a halt from that perspective in the Spanish landscape or market. It may take different ways, but people are there and willing to test and experiment. Right?
Yeah, and we all like finding solutions to those thorny issues.
Yeah.
Excellent, thank you. I think we are up against time. It may be that we have a brief moment to take a question if anybody has one. I see, there we are. Is there a question there?
Given the comment that there have been no class actions in France in the last 2 years, does that mean that people who would seek remedy in France are going to other jurisdictions like Spain, and therefore the French consumers have no local protection for their interests?
It's fair to say that we have seen some claimants leaving the country and deciding to litigate in other jurisdiction, and we can see that actually the directive is emphasizing to a certain extent competition between European justice. And so this is happening. We have seen that as far as a number of French claimants are concerned, but not consumer. Because, and for it may be a pity, but consumers cannot afford or are probably not in the best position to afford going to another jurisdiction in order to have their case adjudicated, whereas a number of businesses have done so. So what we have seen in respect of consumer claims is not a trend going down. It's a trend circumventing the class action regime, which has been really put in place in order to achieve that. So it's really why I was talking about a failure, because in 2014 there was a clear acknowledgement that consumer claims had to have a proper mechanism in order to be decided in the best interest of all stakeholders, including the consumers. This has not happened to a large extent. Does not mean that consumers are not protected under French law. They are because of the criminal rules. They are because of the creativity of some claimant spokesperson, if I may say so. They are also because of the French administration. GCAS24, which is the French consumer agency, is very active. So I would not draw this conclusion. What I can observe is a certain degree of inattractivity of the French regime and the French place, which I think is the result of what I said about the class action regime and prompt for a reform, because we can be on the claimant or defendant side. What I think is the worst position to be in is having a device which is not working.
Thank you very much. I'd just like to say thank you to my fellow speakers and to you all and to GLG on their behalf for inviting us to speak today. Thank you very much.